But you will try as much as possible to write. Now, the English law was extended to Nigeria in October 1st, 1960, when we had our independence. However, there are some laws that, tried as much as possible to come up apart from the constitution that was, that was, you know, we call it the independent constitution. When we had our independence, there was a constitution to that effect that will guide our law. So such constitution came, or laws came up, like the Copyright Act 1911, but was repealed by decree 1970. We have the criminal code law, the penal code, and the Independence Act of 1960, like I said before. The Independence Act of 1960 was actually the constitution of the Federal Republic of Nigeria as amended in 1999. Presently, we are still trying to amend more of the constitution. We are still trying to amend it. The Constitution of the Federal Republic of Nigeria has the following characteristics. It is said to be supreme. The Section 1 of the Constitution provides that the Constitution shall be supreme, and its provisions shall have binding force on all authorities and persons through the Federal Republic of Nigeria. That is, it is all and all. No other constitution stands aside from the 1999 Constitution as amended. In accordance with the Constitution. Then another item that section or subsection of the Constitution that buttress the fact is subsection 3, which states that if any other law is inconsistent with this Constitution, the Constitution shall prevail. The Constitution shall prevail. If you have any other law that is inconsistent, that is saying different things from what the Constitution says, the Constitution shall prevail. That is another characteristics. The last characteristics that I will give you is that it is written and it is rigid. Our constitution is written down, unlike some constitution of other countries that are not written. So, and the meaning that is rigid, when we say the characteristics of rigidity, what it means is that it's always very difficult to change. Many times you can only amend, you can't change. As it were now, the National Assembly, the Parliament, is even trying to amend a lot of the Constitution. As I'm talking to you now, they are trying very hard to amend a lot of the Constitution. And they've not been able to do that. So, what we are saying in essence is that it's rigid. It's rigid, difficult to amend. That is, they have to take two-thirds of the majority of the State House of Assembly to change the Constitution, to amend it per se. Apart from the Parliament, the National Assembly, and the House of Reps, Federal House of Reps, and Federal House of Assembly. Apart from them, it will take two-thirds of majority of the state houses. All the states in Nigeria, two-thirds of the states we sign to it. If not, it cannot be amended. That is supremacy of the Constitution and its characteristics. Another characteristics is that it is federal. That is, we practice federalism. It is a federal constitution that divides the power of government between the federal government, the states of the federation. The federal government are the one that have the power to legislate on matters in the exclusive legislative list. Now, the federal government law are called acts, while that of the states are called laws. If a state a federal government act on same subject, the federal government act will prevail. That is, it supersedes the state's law. Another characteristic is separation of power. That is, to avoid confusion, the Constitution separates the powers of government among the three branches of government. And the three branches of government are the executive, the legislative, and the judiciary. They are the branches of government, the executive and the judiciary. So all these branches are independent and have their own powers. The executives are like the president. When it comes to federal government, the federal president. When it comes to states, the governors and its commissioners, the deputy governor, the governor for state, the governor, the deputy governor, the commissioners. For federal government, you have the president, vice president, and the ministers. They form the executive of the federal government. Whereas for state, you have the executive for state is the governor, the vice governor, and the commissioners. While that of local government are the chairman, the deputy chairman, and his councillors. And that's supervisory councillors and the supervisory councillors. They form the executive in local government. Then for legislature in federal government, you have the House of Assembly and House of Reps, Federal House of Assembly, Federal House of Reps. For state, you have the State Assembly and State House of Reps. You have the councillors. Judiciary, high courts. You have the federal high courts. You have the Supreme Court, the appeal court, and the federal or state for federal government. But for state, you have the magistrate court, you have and other lower courts, district courts for state. Courts. And some other type of courts or other type that are brought up by the local government executives and legislators, because the legislators in local government are actually the councillors. Are we there? That's the appointed local government are called the supervisory councillors. So all these powers are separated so that you will not encroach, the executive will not encroach on the legislative powers or the local government powers. So it is done this way to separate the powers and are supposed to be. Now we have the rule of law. We have the rule of law is another characteristic. The rule of law is another characteristic of the Constitution. There is rule of law. What do we mean by rule of law? What we are saying is that no one is above the law, because Constitution has given powers to govern according to the law. You are not expected to discriminate the rich from the poor. As the law affects the rich, it affects the poor. So the principle of rule of law is expected to abide. That is, you don't just apply the law arbitrarily or subjectively. As it affects the black, so it affects the white. As it affects the black, so it affects the white. And one of the characteristics of the rule of law is that, or the principle of the rule of law has two broad aspects. A person shall not be judged in his own case. You cannot be a judge in your own case. You have a case with your neighbor, and you are the one that's sitting as the judge. The rule of law says no. The principle of the rule of law says no. That's nemo judes. It's a Latin word, nemo judes. Nemojudes. You cannot be a judge in your own case. And the other aspect of it is a person shall not be condemned without hearing. You cannot condemn somebody without hearing. That is, you must assume somebody to be innocent before judgment. You assume that the person is innocent, even when you catch him in the act of committing a crime. You caught him in the act of committing a crime. You must assume that he's innocent before he is judged. You must assume that he's innocent before he is judged. You can't condemn him when he has not been judged by a competent court of law. By a competent court of law. Another characteristic is fundamental human rights. The Constitution gives you a fundamental human right. And what are the rights? It is found in chapter 4 of the Constitution. that you, as a Nigerian citizen, is entitled to enjoy some of these rights, which include number one, right to personal liberty, freedom, right to personal freedom. You cannot be locked up in a house. Probably they want to they make sure that you don't go out. You are now locked up in a house. They kept food for you. There's light. You can watch TV anytime you feel like. You can sit at home, not going anywhere. They've taken away your right of liberty for a day, for 2 days. Unless a competent court of law say you should do what? They should do that to you. Personal liberty. Right to fair hearing. I've said it before. You cannot condemn someone without any hearing. You must take the person to court and let the court hear such person. Right to life. You can't even take your own life. You have committed a great crime if you are caught. If you decide to commit suicide, government will hold you and lock you up for life, because that is a great crime. Right to life. Right to dignity of human person. Nobody should look down on you or disrespect your dignity of human person. Make you a slave. Make you a slave. Tie rope on your neck like a dog. No, it is not allowed. Or find a way to indignify you, making you less than a human being. Making you less than a human being. Number next, right to private and family life. No one can stop you from getting married. If you get to the age of getting married, you can choose your husband, choose your wife, and live a private life with them. Right to freedom of thought, conscience, and religion. You have the right to think like Rastafarian, to think like a Christian, to think like a Muslim, behave like a Muslim, behave like a Christian, behave Rastafarianly. Right to freedom of expression and the press. You do not ask the press not to write what they see. As long as they can prove it, you can express yourself. But there is difference between expressing yourself and, infringing on another person's right. If you infringe on another person's right, you have committed a crime. You have committed a crime. Right to peaceful assembly and association. You can decide to form association of close friends, association of fat friends, association of slim friends. Nobody can stop you. Association of book readers, association of tall ladies, association of middle height or average ladies, association of You name it. Any association you feel like forming, you have the right of peaceful assembly, but it must be peaceful. It must be peaceful. Right to freedom of movement. You must move where anytime you feel like moving, except there is coffee, except the government says don't move. Aha, you don't move. But there must be a reason. They cannot just say don't move. Probably it's for your own safety. So freedom of movement and right to freedom against discrimination. Nobody should discriminate against you. You have freedom against discrimination. It's not in anybody's power to say, why are you not tall? Why are you too tall? Why, some people discriminate. This one didn't go to school. I beg, keep him aside. Or is physically challenged. Because he's physically challenged, you are discriminating against such a person. You are committing a crime. You are committing a crime. So many a times, if a citizen's right is infringed upon, you can approach either a state high court or a federal high court for redress under the Fundamental Human Rights Enforcement Procedures and Rules. So when we talked about arts previously, the federal government passes arts. The branch or the branch of government or the arm of government that passes this arts are the National Assembly, which consists of House of Representatives, the Senate and the House of Representatives. They call them the National Assembly. That's the Senate and the House of Representatives. They are the one that passes acts. Then there are those that pass decrees. That's the military government, the federal military government passes decree. Then I've told you that the law are passed by the states, while edits are also made by the military of a state during a military government. So edit is like law. Law is passed during civilian government, while edit is passed by states during military regime. Then we have bylaws. These are laws made by the local government councils during democratic and military regime. Bylaws is for local council. Doesn't matter whether it's military regime or civilian government, but it's made by local government. Now we have the customary law, which are also followed by the customary court in local government. So the customary law can be said to be different kinds of rules. And these rules are regarded to be obligatory by members of a particular community. Many times, the judiciary arm of the local government are the customary laws, and they actually, form their laws from their community. We have different types of customary law. Number one, we have ethnic customary law. Just like the name sounds, it's more indigenous to ethnicity. Then we have Islamic customary law, which is based on the Islamic faith. Which is based on the Islamic faith. Now, how do you identify a customary law? How do you identify a customary law? Many customary laws are unwritten, except Islamic law that follows the Quran. Except Islamic law that follows the Quran. Another characteristic is that the law is meant for members of the community or group to which it relates generally. So it is mostly like traditional marriage and all the rest. And the community must accept it or consider it as binding. So many a times, it must be accepted by the community of that area. So it is said to be mirror of accepted usage. Mirror of accepted usage. It is largely flexible. It is largely flexible too. That's one of it. As stated in Osborne CJ, who observed in the case of Lewis versus Bankole. So many a times, customary law looks at the motive of expediency without losing its character. So what we are saying is that it's always based on kind of custom. It's based on custom. What is it that the custom actually wants to achieve? What is it that custom wants to achieve? Validate. How do we validate customary law? That is, give it validity. What do I mean by validity? Validity is make it acceptable by everybody that finds himself in a customary court. What is it that gives it the value that it has, that makes people go to customary court? Now, one thing is that the customary law does not, recognize or enforce all customs, because customary law came from the customs of a community, of a people. And it's flexible because many customs are different. Many of the customs are different. If you go to a part of the community, the way they do their things are different from the way they do their things in some other cases. There's a case that there's one man, he has money, so he has a lot of money. He now took somebody's chieftaincy title because the man doesn't have money. By the time they went to court, the 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 court, the man came with some other high chiefs, while the one that doesn't have money came alone. So when the case was brought up, they asked the others, is this man your chief? The other one say, yes, yes, he's our chief, he's our chief. The man was saying, no, it's not. He came, he took over my chieftaincy title. He said, no, 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 no. The judge had to give it to the man because he has people that testify, and they are chiefs in that community. So if he has people,
Hello? Hello?
what do we mean by repugnance or repugnancy? That is REPUGNANCY. That is, it must pass the pregnancy test. It must pass the pregnancy test. What we meant, what we are, hello?
Hello, the network distorted. I didn't get what you're saying before getting to the last thing you're saying now. To what you're saying now.
What I said is that
After the
there are
chief, after the title was given to the man in the court, the one that has witnesses, that is where I
the one
stopped.
that they felt that it is from their custom to accept such a person, and because it came with other chiefs of that community, and customary court, you know, respects customs, though not all customs, it respects customs, and it gives its judgment based on the custom of that area. And the custom of that area is when it is accepted by majority of the people. So the man with money was able to bring, whichever way he did it, I don't know. But what happened was I was able to bring more chiefs. Out of about 12 chiefs, 10 of them came to, speak for him. So customary law is saying that that's why it looks at the majority accepted custom. If it is accepted that the man is part of the chief and the other one is not, that is the way it is. If he was able to bring majority of people, maybe members of the community and they stood for him, probably the judge would have spoken for him. But because in the court, in the customary court, they had more people that came. So it happens in different communities like that, all over the world. So customary court look at it is now saying that number one is that the characteristics or the test, he has to pass 3 tests. Number one is that he has to, for the customary law to be valid or to be accepted, the law to be accepted, it must pass 3 tests. Number one, repugnancy test. So I spelled it REPUGNANCY test. It must pass incompatibility test. Incompatibility test. I will explain them one by one. Then it must pass public policy test. Public policy test. Now let's look at repugnancy test. I said it must not be repugnant, that is to nature, or to natural justice and good conscience. What I'm saying is that it must not be against natural justice and good conscience. Now, what is good conscience? You are somebody is owing you some millions of naira. Now you went ahead to go and do what? To go and pick the wife of the man. Take the wife as your wife, and the children to come and start serving you. It is kind of repugnant to natural justice. What are you in a jungle, your zoo? That is what the question they will ask. Shall you understand? It's not acceptable. It's not acceptable. Number one is repugnant to natural justice and good conscience. To go and take somebody's wife because she's owing you without the consent of the man or the woman. I don't know whether I understand.
Yes, sir.
So we look at a case of Edet and Essien, 1932. Edet and Essien, 1932. In this case, Essien married X. After paying dowry on her, later, X deserted Essien, and without a refund of the dowry paid by Essien, married Edet. 2 children were born out of the relationship between X and Edet. Essien claimed those children as his own on the basis of an existing custom that provided that as long as the dowry paid on a woman had not been refunded, any children born by that woman belongs to the former husband, whose dowry had not been refunded. The court held that such a custom was unenforceable because it was repugnant to natural justice, equity, and good conscience. It happens. It happens. Even in my own place, it happened.
Yes, sir.
Eh? They start claiming the children. They start claiming the children. It happens. But the court said no. It's repugnant to natural justice, good conscience, and equity. It sounds somehow. Another characteristic, this thing test he has to pass is a incompatibility test. Incompatibility test. Now, what he's saying is that every customary law must not be incompatible, either directly or by implication with any law for the time being that is in force. It must not be incompatible. An example of a case that cannot be enforced is Adesubokan, Ade Subokan versus UNISA, UNISA, YUNUSA, 1971. Now, this is about an Islamic rule. An Islamic rule on inheritance, because in that particular case, it conflicted with an existing law, that is, the Wills Act of 1837. The Wills Act of 1837. Now, what happened is that a will was written, but when the man passed away, the man wrote a will and gave the plaintiff the right to his property. But the defendant said no, that the Islamic rule says something else. Like, take for example, it says that the defendant is the first son, but in the will, the man gave this thing to one of the son, not the first son, not even the second son. His property to will it to the good son. Let me put it that way, the good son. He willed all his property and everything he has to the good son. Why the first one now said no? They went to court. They said the man has written a will. If he has not written a will, it's another thing. So you cannot enforce the Islamic rule that says that the property should go to the first son. That is the case as it were. Now, I said it must meet public policy test. Section 14, subsection 3 of the Evidence Act provides that every applicable customary law must not be contrary to public policy. Now, there are decided cases that buttress this point. I have Alake versus Pratt, 1955, and Cole versus Akinyele. Now, what happened is that the court refused to enforce certain rules of customary law because in the opinion of the court, they would encourage promiscuity. They will encourage promiscuity, which is contrary to public good conscience. Now, what he's saying is this: a child born out of wedlock, a child born out of wedlock was to be what? Was to be legitimized. That is, they want to make him a legitimate child. He was born out of wedlock. He was not married. The father did not marry the mother. He just went and did a fling. When he flinged out a child. He flinged out a child. And they now want to make the child a legitimate child to, to inherit the father's wealth. But the court said no, that it will encourage promiscuity. That is, it will encourage men going out, giving birth to children all over the place. Giving birth to children all over the place. And if it's even going to be accepted for public good, there are the following conditions that must be met. About 3 of them. Number 1, there must be a direct oral evidence. That is, the man must have accepted the child as his own and must have said it to the hearing of others. Apart from others, he must have said it to the hearing of chiefs. Hearing of chiefs, elders, etc. And these are people that the court, look up to as a custodian of judicial notice. So such must be, given to the court before the court can say, okay, it's true. But without these conditions, he said there must be documentary evidence too. This involves tendering of evidence, such as books, manuscripts, or research findings of people who are considered experts and knowledgeable in the custom intended to be proved. Then number 3 is that there must be a judicial notice. What it means by judicial notice is to ask the court to accept the custom as existing because a higher or coordinate court had in previous proceedings repeatedly accepted the custom as existing. When we say coordinate or higher, we are saying a court that is higher than that customary court has accepted such thing before. That accepted that judicial precedence We call it judicial precedence. Has accepted. There's a judicial precedent where it was accepted. So that judicial precedent will be brought to the notice of the court, of the customary court. Or coordinate means equal jurisdiction, equal power, equal jurisdiction, equal power, equal jurisdiction. That's what it means, that they have equal power. There's a court that have accepted it, that has equal power with the present court they are in. So that judicial notice can be given to the judge, and the judge will accept, will choose to accept to. It's not like they will be forced to. And that is called what we call judicial precedent or case law. Now, another source of law is this one that I have said, judicial precedent. That's another source of law, is judicial precedent, where a higher court or a court with equal jurisdiction or equal coordinates have stated the rule. And this case you are looking at is like that case. You now see or say, in so person case, this is how it was judged. That judicial precedence. This is how it was judged in so person case. And because it was judged like that, at the end of the day, what happened? We were able to do what? The court will now look at it and said, okay, and follow the precedent. It might follow the precedent, or it might deviate a little, or it might decide not to follow it at all. Yes, you go and appeal. So that is judicial precedent. Now we have different types of judicial precedent or precedents. We have original precedent, we have binding precedent, then we have persuasive precedent. Original precedent, we have binding precedent or persuasive precedent. Are we there? Now, what is original precedent? Original precedent is a point where that type of case has never been decided before. The case has never been decided before. Now, the decision of the court concerning that case is an original precedent. No court has ever judged such a case before. So now they judge that case, they put the case down, and everything has been written down, and the judgment has been given. It means that it's original precedent. It means it's original precedent. Are we there? Binding precedent. Now, a binding precedent is when a superior court have judged that kind of case, and that case comes to a lower court. We will get to know a lower court and a superior court very soon. So when a superior court or a higher court has judged a case, and that case is the case that is in the lower court is exactly like that one. What it means is that the decision that was taken in that superior court is binding on that lower court. So the lower court had to follow that precedent, because it is binding on the lower court to follow the superior court. The superior court is seen as higher, so the decision is higher. So they expect the lower court to, to follow the superior court, and that is a binding precedent. Persuasive precedent, just like the name sounds, it is not binding. It means that the other court can decide to follow. Take, for example, the decision of a higher court of the Federal Capital Territory is of persuasive authority to the High Court of Rivers State. That is, the Court of Rivers State is not, they are kind of the same rank, coordinates. They are kind of the same coordinates. So the Rivers State High Court is not bound to follow the High Court of the Federal Capital Territory. It's not bound, but it can decide to follow if it's persuaded. If the court is persuaded, in that case, that looks alike, it can decide to follow. Now, there are terminologies in precedent. But before that, terminologies of now, one of them is overruling. Many times we used to hear overruling. When this happens, when a higher court in the hierarchy of courts overturns the decision of a lower court on appeal. Take, for example, high courts now make a decision and you go to appeal in appeal court. Appeal court now overturns that this thing. You say go right. Appeal court say no, go left. That is overruling.
Okay.
That's overruling. Distinguishing.
That's number 2.
That's number 2. Distinguishing. Distinguishing is when it's like a method that is used by a judge to avoid following the past decision. That's a precedent, to avoid following a precedent that he could have been bound to follow. He could have been bound to follow that precedent because it's a higher court or it's a court of coordinate jurisdiction. But because he distinguished the case from the other one, he refused to follow it. Maybe he found something distinct, something different from that case. So he refused to follow the decision that was made in the past case. You will say is distinguishing. Then we have reversal. Now, the reversal looks more like overruling. Overruling, the difference is that with overruling, the court will make a different rule. the court will make a different rule so that it can move to the left. If the past one said go right and he said go left, it will make a different rule from the rule that say go right. You know, court will always tell you why they are going right. The same thing in overruling, they will tell you why they are going left. But reversal is that, but in reversal, the court of appeal will totally reverse using the same rule. With the same rule, it will reverse the case. But in overruling, it will make a new rule for reversing the case. But in reversal, it will just reverse the case with the same rule. I don't know whether you understand. That is what it means by reversal. Another one is.
Please pardon on this. That's. He said you don't want to explain the reason for.
Korea. INCURIAM. This is a kind of overruling of a court, but the court is not a higher court or court of appeal, but it's the same court that gave the judgment initially. It can now overrule itself, probably because he found out that he made an error or it made a mistake. If it made an error or it made a mistake, it can overrule itself. It can overrule itself. Now, there are advantages of judicial precedent and disadvantages. You will see that if you follow the rule of previous case, or you don't follow the rule of previous case that look alike, it makes things easy for the court. It saves time. They can easily say, in Lagbaja and Lagbaja's this thing, Lagbaja 1, Lagbaja 2 case, this is what was decided. Now, this case is exactly like Lagbaja 1 and Lagbaja 2. There's no need wasting time. Let's follow the rules that were stated in Lagbaja 1 and Lagbaja versus Lagbaja 2. It makes it easy. It saves time. It saves time. And it makes law to be consistent. There is consistency. There is consistency. And it helps people to know the law. It makes people to know the law, particularly when you can go back and look at the case law or precedent judgment. It makes you to know the law. It was done like this during so person's own. Why are they doing it like this during my own? It gives knowledge. One of the disadvantages is it makes law static, rigid. When you keep on following this, even if it's wrong, you keep on following it. It makes it rigid. There's no flexibility. And when something is rigid, you don't use your initiative again. You see, judges, they follow this, they follow that, when they know it is a wrong thing. No initiative. We don't bring in initiative in law. And many times, there are cases that are similar, that were judged a long time ago. So it makes it difficult to even make reference or to find precedent cases. It's not easy to find precedent cases too. And it leads to slow development. Slow development, where there is no initiative. You will see that the law will become, development of law or adjudication will become slow. The wheel of adjudication will be slow.